Hello everyone, this is Rajiv. Welcome to our conference call. As the recording that announces your arrival in the beginning tells you, this call is being recorded and it will be made publicly available, so be careful about what you say here. As usual, I'll get started first with the questions that have been posted on the forum, then take up follow-up questions on the questions that were posted, and then take new questions. But I always try to make sure that everybody's questions are answered. So even though you're at the very end and you have not posted anything, don't worry. I'll make sure that I answer everybody's questions. Okay? Ravi wants to know, my visa has expired, but my I-94 is still good. He's on L1B. Is it okay to work on I-94? The answer is yes. The way it works is, visa is only a document that helps you enter the United States. Once you enter the United States, your legality of stay is determined by your I-94 in the right category. So if you have an L1B I-94, you can continue working even after the visa expires. Next question is from VG. Guys, don't call me sir, just call me Rajiv, okay? It says, Dear Sir Rajiv, I'm from India. Change job after 6th year of H1B extension, green card application file. Okay, so his 140 is approved and he wants to change the jobs as soon as he receives his H1B extension. He wants to know, what is the process? How can I do this? Well, a couple of things you need to keep in mind, Abhijit. Let me see where to begin. First of all, once your I-140 is approved, the priority date becomes your property forever. Unless the I-140 is revoked for fraud, your priority date will not be taken away. Okay, that means even if the employer revokes the I-140 after you leave them, your priority date cannot be taken away. But here's the bad part. If your employer revokes your I-140, any further extensions or transfers of H1 will not be possible. So here's what you should do. You should make sure that you get your transfer approved with the new employer, okay, and you get it approved for sufficient time, 2 years, 3 years, whatever time, and then you move over and immediately start a new green card with the new employer. That's what you would be doing. SK 2008 AC21 after H1B transfer. So in 2009 his company filed green card, 485 was filed, EAD was approved in 2012. Employer has two companies. 6 months after filing 485, they moved SK 2008 from company A to company B. So they also did H1B transfer, which is good till 2015. They did not file AC21. Attorney is suggesting to do AC21. In most cases, I do it. And even if you didn't do it before, it's perfectly fine to do it now. It's not required. Actually, if you go to my blog, there is a lot of information on AC21, and these questions have been answered in detail. Okay, I would file AC21. Once you file AC21, your status doesn't change. It is still the same status. Okay, is your H1B still valid after you file AC21? Definitely, definitely. If my employer closes company A, is there any problem? No. Because AC21, the idea is you're taking same or similar job with some other company. Okay, so you're fine. No worries. Vkong001, that's Vikram. He says, currently I'm on H1B third year, working for a client. Client wants to hire me on. So can I ask my original sponsor to continue with the green card because the new client will only apply an EB3? And the answer is yes, Vikram, but here is the problem. The essence of a green card application, when you file a green card application, there is a representation in there from both the employer and the employee that says, look, Mr. USCIS, I, the employer, intend to hire Vikram on a full-time permanent basis. Permanent means, doesn't mean forever, it means indefinite. So full-time, indefinite basis upon approval of his green card. So it is not required that you be working full-time permanent for that employer before getting the green card. The employee is making a representation that I intend to work full-time indefinite for this employer. So both these things have to exist. Good faith filing, okay? My problem with your situation is this. Why would you go work with another employer if your green card is going through this employer? And how can this employer, the one who sponsored your green card, justify, if asked, um, why did you let this guy go? Why did you let Vikram go if your job was permanent? Who's doing it? So that can become problematic. Now, I'll give you this. That question has not come up very many times, but it has come up at least once in the last 30 years of my practice. Okay. So your three questions are, can I work for a client without a green card process from the client? Yes, as long as you have a good answer to these questions. What kind of problem? They can come after your green card. What should I do after priority date becomes current? So in other words, do I rejoin the old employer? That would be great if you can do that. Okay. So preferably get the new employer to start a green card under EB2 for you. If you can't do that, make sure there is a good faith explanation for why you are leaving them and joining the new employer. And lastly, I lost my train of thought there for a second. Oh, yes. Lastly, even if you do leave them, it may be a good idea to rejoin the old employer on a permanent basis, again, indefinite basis, after priority date becomes current, or at the time priority date becomes current. I think that would be a good way to go. Sokal has an N400 related questions. Guys, at the very outset, I want to make 2 or 3 things clear. One, we cannot help you fill out the forms, because if you look at the forms, there's a question on the forms at the bottom usually that says who helped you fill these forms, and they have to sign. So that's a no-no. We can't do that. Second, I have no expertise in the area of DV lotteries or political asylums. There are 2 questions in today's conference call, I think, about those 2 areas. So you might as well hang up now, because I really don't know much about those areas of the law. Okay. So the question that Sokal asked me is, how do I prove that I did not take a job outside USA for my naturalization purposes? So in my case, I did not work in the US last 5 years. One of my trips abroad lasted for 9 months. We did not keep home apartment while we were away. Husband took a job as he was laid off in USA. I remained a housewife. How do I prove? Well, it's impossible to prove the negative of an assertion. It's possible to prove you and I have a contract with each other if I can show a copy of the contract. How do you prove we don't have a contract? It's very difficult to do that, other than your own statement. So in your case, something like a statement from you that I'm a housewife and this particular clause has no application to me should work. Okay. I also recommend, Sokal, that you should talk with a lawyer. Make sure you go over your entire N400 paperwork and see that there are no other issues here. Okay. And if you feel more comfortable with somebody going to the interview with you, you should talk with a lawyer locally where you are. AAP Desai, Palm case might get void due to attorney fraud and H1B stamping. There is a very odd situation here. The attorney who represented them had committed some fraud and their cases are being denied. Okay. So he has a series of questions. Mr. or Ms. Desai, I need to make one thing clear to you. You may need more than what I can do here. You should have somebody sit with you and go over all aspects of your documentation and make a comprehensive plan for you to protect you and to make sure that the least amount of damage is caused to you. I'll try to answer the best I can. Number one, I was told that the already approved H1B extension, which is based upon this fraudulent labor cert, won't have any issues. You know, it can. It can. I don't mean to scare you, but if the government wants to be really nasty about this, they can come after that and they can say that the H1 extension was approved in error because it should not have been approved since the filing of the labor certification, etc., was fraudulent. They can do that. I have planned to visit India and I want to go stamping done. Don't do that. You can have a problem. So next question is also Mumbai consulate. I will skip that question. I don't think you should go for visa stamping. What else can I do? Difficult for me to say. Definitely start a new green card as quickly as possible. Are there any other legal actions that you think I can explore? One of the things that you can do is you must have a bunch of employees who are in a similar situation. Maybe you can get your lawyer to talk with the US attorney who is prosecuting this lawyer and say, you know what, we are the victims of this situation. What kind of concessions can you get us from USCIS? To have your lawyers talk with the US attorney's office. Maybe there is something that can be worked out. Okay. Is it possible for me to change the job? My problem is if you go to USCIS now for anything or for visa stamping, you are basically exposing yourself to harm. I think you should sit tight unless there's a problem with the company. In that case, you don't have a choice. Okay. Srini wants to know EB2 India versus family-based green card, which is better? So the idea here is, and I read these cases. Today something odd happened to me. I thought I only had 3-4 questions for today's conference. So I just reviewed those questions and I sat back. Then I realized I was reading the questions posted for August 1st and that July was already full. So I had very little time to review all the questions. I did it in about 20 minutes, but I think I've got the gist of everything. If I've got something wrong, feel free to correct me, okay? If I've got your facts wrong. So for Srini, he says, I've got my green card, but wife is stuck. Okay. So PD becomes current in August 2013. And also family-based F2A is current. What I'm doing in these cases is I'm telling people to file I-130 also. It's worth it. Whichever comes first, you get that. I think it's worth it because the priority dates can slip back. And if you have two cases, then in two different categories, family-based and following to join employment-based, it just gives you more protection in my opinion. That's just common sense, I think. R.A. Polu, Ravi wants to know this. Again, don't call me sir, please, guys. Just Rajiv is fine. So, working for a US-based company, 2 locations, Columbia, Maryland, Herndon, Virginia. He's working on an in-house project. Work location initially was Columbia when they got the H-1B approved. Now it's changed to Herndon, but the same project. Normally, let me just give you a quick overview of what the rule of amendment is. When do you need an H-1B amendment? You always need an H-1B amendment when there is a change in jobs, whether it's change in clients, change in locations, change in projects. You always need an amendment, an H-1B amendment. The only exception is if it is the same job, same project, same end client, and within normal commuting distance. So Columbia to Herndon is normal commuting distance. And if it is the same project, same job, H-1B amendment should not be necessary. And I don't know if when you filed the H-1, did you actually list both sites in the H-1 paperwork and gave LCAs for both sites? If you did, then there is no problem. If you did not, I think at the very least your company should file an LCA for the Herndon location. I don't think H-1B amendment is necessary. So you're now going for visa stamping. Do I need to give H-1B approval and H-1B amendment? Well, you haven't filed the amendment and it's not needed. So you'll only give the H-1B approval. But I think you should carry the LCA with you just in case they ask for it. If they ask for your work location, you should tell the truth, whatever it is. Don't try to hide it. But if they don't ask for it, I don't see any need to talk about it. Okay. Do I need to submit new DS-160 based on amendment receipt number? Again, I don't even know why they are doing the amendment. I mean, I saw that they had applied for it. Not sure why they are doing amendment. I'm a little confused. Amendment should not be necessary. So if you don't do anything with that amendment, that's okay. But double check with your lawyers. I'm not sure why they filed the amendment. Maybe there's some change that we don't know about. Okay. But if there is no change, same end client, same job, everything's same, just a change in location within normal commuting distance, an amendment is not necessary. You don't need to bring it up at all. Okay. Then next question is Sri D Reddy. Interlinking of filed I-485 in EB3, and this was an interesting situation. So wife has filed under EB3 and she also filed 485 at some point of time, but the priority dates have retrogressed. Okay. Now his priority dates under EB2 became current. So wife's 485 is already pending as her own primary. He is filing as his own primary his 485 under EB2. How do we link wife's 485 as a dependent or a derivative to your EB2, which is current? And the answer is USCIS should automatically do it. Okay, they should automatically do it. They will move her application to your and link it to yours automatically. They are supposed to. I don't see any harm in your lawyer adding a letter requesting the linkage, giving a copy of her 485 receipt right when they file your 485. That's the way I would do it. Okay, I don't think a new 485 should be necessary. So next question is from Hardik, who says, how do I prepare a statement of reasons for a J1 waiver to submit to State Department, I guess? So you're not a graduate medical education person, no residency. You are doing basically, you are a researcher, medical researcher. I think you already know, yes, for State Department, you already know that what they are most concerned about is that you should not have had a preconceived intention to get a J1 waiver. So you should be clear about that. If that's the truth, that your intention changed, obviously you came here, you fell in love, and then you got married. If you make those facts clear, I think that's as good as you can do. Okay. Next question is Zyfax, who wants me to answer certain questions about filling Form I-90. I cannot do that because they're applying for a green card or renewing a green card that has expired. So I can't really help you fill out the forms. There is a lot of information that you don't have. There are two ways to get this information. What you can do is, I think it's called Form I-639, the Freedom of Information Act request form. File that form and ask government for all immigration information related to you. In a few weeks, you will get all that information. Okay, and it's free. Second thing, simultaneously what you should do is contact US Customer Service and ask them these questions. Okay, from your A number, they might be able to help you with some kind of documentation that would take care of all these issues. You could even do an InfoPass appointment and go to the local USCIS office and present your questions to them. I would do all three things. Okay. MacBoss says, hi Rajiv, I'm currently employed. Okay, I remember this situation. So currently MacBoss has a quota exempt H1. They are going to start working on a quota H1 simultaneously on a concurrent basis. That's fine, you can do that. That's a loophole in the law that doesn't make much sense, but it's there. But remember, if you stop working for the quota exempt employer, the quota job I don't think is legal. I have not read this for a while. But last time I remember two things relevant to this discussion. One, you cannot quit the quota exempt job, otherwise the concurrent quota job goes away as well. And number two, um, I don't think you get an exemption from quota. For that, you have to file again on April 1st. Okay. How long does it take to approve a concurrent H1B? The same time as a normal H1, and you can file premium processing if you like. I think that answers all your questions. Right. By the way, you said, what if I get laid off from the quota exempt company? Same idea. Whether you get laid off or you quit, it's the same problem. Okay, next question is about political asylum. My apologies, I don't know anything about this area of the law. Page 123 wants to know um, dependent visa stamping current on I-94. Colleague is in USA on I-94. Oh yeah, I understand, I remember. So somebody is here on L1, but their visa has expired. I-94 is current. If their dependent, for example their daughter, wants to go for a visa stamping of L2, is it going to be a problem? The answer is no. The answer is no. Unless the consulate insists that no, Mr. L1, you will go get your visa stamping. Normally, it is not a requirement of the law. It is not a requirement of the law that the primary, like L1 or H1, must have a visa stamp on their passport for the dependents or the derivatives to get their H4 or L2 stamping done. But consulates can require it. They can insist on it. They are inconsistent. Sometimes they do, sometimes they don't. So go try for the L2. CSPA. I'm a little confused with this question from ECE. I don't have enough facts. Is there any further step after my dispute I sent to USCIS for my sister's change of category? See, generally speaking, when you have a dispute with the USCIS, you can always open a case with Ombudsman's office. Ombudsman. O, M as in Mary, B as in boy, U, D as in doctor, S as in Sam, Ombudsman as in man, woman. And Google USCIS Ombudsman or Yahoo or Bing, whatever you use. Do a search for USCIS Ombudsman and open a case. They can help you with these kind of situations. Debbie Souza wants to know, I'm a student living in Miami. I've been here for 6.5 months. Can I get some kind of a work authorization, work permit? See, Debbie, as far as I know, those are only available for people who have been here 2 full semesters. So any kind of work authorizations related to finishing up of your coursework has to be 2 full semesters. Okay, you can double check with your DSO. Okay, you can double check in your International Students Office with your DSO, designated school official, and see if there is any exemption or anything they can rely upon to get you work authorization. I'm not aware of any. Okay, ZMMA, I'm sorry, DV question, lottery question, don't know anything about it. AZZM2 says changing employer soon after getting green card, AC21. I actually did a consultation on this just about half an hour to an hour ago. The question is, I got a full-time job offer. Priority date is 2007, becoming current in August 1st, 2013. Could you please suggest if I can accept a full-time job immediately after getting the green card? You know what? I've answered this question so many times. Please review my blog. I have a full-length discussion on how soon can you leave, what is the effect on naturalization. I'll give you a quick rundown, a quick version, and hopefully that will be sufficient for you, but I want you to read up my blog. Okay, so the way it works is, on the date you get your green card approval, you must have the intention to work at that place indefinitely. And it's not permanently, indefinitely. That means you have no plans on leaving right away. Okay. Is there a certain number of months that's a safe period? As long as possible, 6 months is good, but there is no rule on this. 3 months is okay, I guess, but there is no rule on it. I would say if you are leaving, document certain things. Document the fact that you are getting a much better job offer, whether it is more salary, a promoted title, better chances of promotions, bigger company, more established employer, work more to your liking, any of those things. If you're leaving before 3 months, document those things, and how the work is basically similar. That could help you, but this is not a hard and fast rule. Okay. Is it fine to file AC-21 until the day prior to green card approval? Yes. Yes. I have had cases where I actually filed AC-21 after the green card approval, just to make sure that I had it on the record that we tried. So a person moved from company A to company B, and we knew the green card was getting approved. We filed the AC-21 anyway. And of course that went into a junk box somewhere. We don't care. We have proof that it was sent out. FedEx delivery is proved. So if tomorrow during citizenship process it becomes an issue, we can show that we moved to a same or similar job. And that's what I'm going to ask you to do as well. It doesn't have to be the same job. It can be similar. Career advancement is okay. I hope that helps. Samir wants to know questions regarding green card through F2A category. Family based is current right now. I guess he's a green card holder, obviously. The dates for family based are current. It is predicted to be current till October 2013. Nobody can tell you for sure. Fiancé is a green card holder. She's in USA. Fiancé is in USA. I was in USA till 2011. I'm again trying to come back on H1. I would like my fiancé to come to India for marriage, then file I-130. Once my I-130 gets approved, both me and my spouse can go to US consulate for interview and get green card. Well, that's assuming that in that much time, and let's say if priority dates are current till October, they process all these things. It can take time, a few months. And I cannot tell you how long the dates will remain current. You asked me that question. Can I file green card? Sure you can, but the problem is there's no way to predict how much time the consulates will take. Do you advise me to, is there any scope for proxy marriages? No, they are illegal in the United States. Proxy marriages are, let me rephrase that, proxy marriages are not recognized. Do you advise me to come to USA on a tourist visa? No. Fiancé visa is not available. Any other visa category? H1, absolutely. Then you can get married, no problem. Okay. But H1, I'm sure, I don't know about your quota issue. I think you don't have a quota issue because you used to be on H1. I think you'll be okay with that. So, no, but don't come on a tourist visa to get married. That could be considered to be fraud. So, next question is, if my lawyer files at the incorrect USCIS center, do I lose my place in the H1 quota? And the answer is, I'm sorry, I think you will. The filing has to be done in the right center, so the petition will probably be rejected. You should be prepared for that. Next question is from TVU. I guess this was somebody involved in Tri-Valley University problem, and they were in USA for about 15 days after the school shut down. Does that create a problem for my green card process? No, nothing to worry about. Whether you do an I-130 or an I-140, I don't think 15 days is going to be any problem, because especially after you've gone outside and come back in again. I'm not concerned. It's nothing to worry about. Rohit Agarwal, 19, working on H1B, having contract in India. I'm working on H1B and looking for a change to some other employer. New petition is already approved. I had signed a 2-year contract with my old company in India. Now, first of all, I can't comment about Indian laws. Okay, you have to talk to a lawyer in India. But your lawyer can present evidence that US laws take a very dim view of contracts that restrain people's right to work. And in the H1 area, they don't like contracts that are um, based upon punitive measures such as, if you quit me, you'll give me $50,000. They don't like those contracts. In fact, if somebody makes you sign that kind of contract, you can complain to the US Department of Labor. I actually have a full article on this issue. Um, Let me show you. If you want me to send you an article on this liquidated damages contract clause, it was published in an American Bar Association publication, American Law Institute publication. Um, it's about how those can be very problematic for employers. Okay, I'll send you. It's on our website. If you go um, on About Us, my biography is there, and then articles written by me. You'll see there's an article on liquidated damages clauses in contracts. Okay, download that. Have your Indian lawyers review that. That might give them some ideas. Uh, oh, you have other questions. Do I really need to pay that amount? Probably not, but that's something you need to talk with the Indian lawyers about. And you can also complain to the US Department of Labor as well as USCIS. Complain to Wage and Hour Division, okay, of the US Department of Labor. Can company do any harm in US? I don't see what they can do. I mean, if it's a contract in India, like I said, but I don't want to comment about the contract issues because that's not my field, and I'm not practicing law in India. They can't. They cannot really hurt your new green card process. I don't see how they can do that. And USCI is not going to ask them anything about your new green card process. Uh, so next question is from Lado Patel. If my I-140 is revoked, can I still carry my priority date? The answer is yes. The only time you cannot carry your priority date forward is if your I-140 is revoked by USCIS for fraud. Okay. Um, Satya KV, H1 rejected. So your H1B got rejected and you're using EAD for the same company. Is it legal? Definitely. I see no problem with going from H1 to EAD by redoing the I-9. You should be fine. Okay. So I think we've covered all the questions. Guys, let's do follow-up questions. Anybody who has any questions that were posted and they want to have a follow-up question on that, press *5 on your phone. Press *5. One raised hand, two raised hands, and once I'm done with this, three raised hands, then I can do new questions. Okay. Okay, three hands only. So let's start with whoever logged in the first. Summit, New Jersey. Go ahead, please. New Jersey, go ahead. Summit, New Jersey. 908673. Okay, I'll go on to the next one. Baltimore, Maryland.
Hello, sir.
Yeah, is this Summit, New Jersey?
No, this is Satya.
Are you in Baltimore or are you in New Jersey, sir?
Yes, I'm in Baltimore.
Oh, okay. Satya, 1 second. Which question number are you?
This is the last question.
Oh, okay.
26.
Okay, yeah. So they basically had you do a new I-9 when the H1 got rejected. I don't see any problem with that.
Okay, and how about for the next one when we go to 2 category?
Let me see, what is that question? See, status as of now, move to employer B, EB2 labor approved, EB2 I-140 approved. Am I eligible to retain EB3 debt? Of course. Will there be any problem during interfiling? I don't see why.
Okay.
Okay.
Okay, sir. That is all.
Good luck, Satyaji.
Yep. Thank you, sir.
Bye. Summit, New Jersey, are you there? Okay, then I'll take the last question from. This is also from Maryland, Washington, something Maryland. Go ahead.
Yeah, this is Ravi. This is Ravi.
Which question number, Raviji?
I forgot this number. This is regarding H1B amendment request. Actually, I'm going to India.
Oh, visa stamping, right?
Yeah, visa stamping. Yeah.
Okay, go ahead, Ravi.
Yeah. Basically, my work location previously is Maryland.
Right.
So recently, I moved to the Virginia.
To Herndon, Virginia.
So H1B amendment receipt. H1B amendment receipt, is it okay? I didn't submit the DS 160 for H1B amendment receipt.
In my opinion, H1B amendment was not even needed. If the project is the same, the end client is the same, Columbia and Herndon are normal commuting distance. I think that should be okay. Okay?
Oh, that should be okay? Okay.
Yep. All right.
Okay, thank you, sir.
Good luck, sir.
Thank you very much.
You're welcome.
Thank you, sir.
Okay, last call for Summit, New Jersey. Okay. All right, guys, last call. If you have a follow-up question, press *5. *5. One raised hand, again from Summit, New Jersey, but I can't hear you. Can you say something? I have.
Hello?
Yes, go ahead, please.
Hello?
I can hear you now.
Hey, yeah, this is Ladon calling regarding that last second question about cancellation of 140.
1 second. Yeah. That is now quite settled that USCIS will not take away your priority date, even if the old employer wants to revoke it, as long as it is not revoked by USCIS for fraud.
Okay, but can employer say that because I saw the field manual say if it's revoked because of fraud or willful misrepresentation, so can employer say I misrepresented this case and now I want to revoke this?
It's a difficult thing to say. Remember, first of all, the I-140 is the employer's application. Okay, so if there's any misrepresentation, they first look to the employer what they have misrepresented. The only way they can claim misrepresentation against you is if there's a problem with the degrees, or you had some lies about qualifying experience. So just by them saying, it doesn't make it so.
Okay, so they even the cancel by themselves, it will not hurt how many priority days, right?
It should not, no.
Okay, yeah, thanks, Ravi.
Oh, you're welcome. Good luck.
Thank you.
Okay, I think Baltimore has another question. Baltimore, go ahead, please.
So this is Satya again.
Yes, Satya.
Sir, now the situation has become a little bit more complex in my case. Like, what it is saying, it has got into an RFE mode. I haven't yet received the letter.
In the last 30 seconds since we last talked?
No, actually, I got it like last couple of days back. I haven't yet updated the question actually.
Okay. So you got an RFE. Okay.
No, I don't know the details actually.
Well, let me just put your mind to a little bit of ease. Most people, everybody who's filed 485 has gotten RFE pretty much. And the RFE says, give us a new letter of employment that shows X, Y, Z, and A, B, and C.
Okay.
So I don't know what your case is, but if our experience is any guide, everybody's getting RFEs.
Okay.
All right?
And like to know the work situation, what would be the other options like?
Look, I don't want to get
out of
into
RSC
I don't want to get into a
to
theoretical
know.
I don't want to get into a theoretical
Okay.
debate because there is so much that can be done and cannot be done. For what reason is the 485 getting denied? Um, you know, can we still refile the 485 or convert it to consular processing? So find out exactly what is going on, then we can talk again.
Sure, sir. Thanks a lot.
You-
And I could not update on because I was thinking today I might get the details and I can
No,
present you, but I didn't receive it even today.
we can talk on August 1st, no problem. Okay.
Oh, thank you, sir.
You're
Thanks a lot,
welcome.
sir.
My pleasure, sir. Okay, guys. Anybody has any question, press *5, please. Three questions so far. No, two. Okay. Two questions only. Very good. Let's start with Brentwood, New York. Go ahead, please.
Hello, Raju. Can you hear me?
I can hear you. Yes, sir.
Raju, I have a question regarding H-1B, concurrent H-1B filing.
Okay.
I'm with an employer A for a full-time job. I got a part-time job opportunity with other employer.
Right.
He wants to know the fees is the same as a full-time job fees for filing H-1B.
Oh, no. Here's how it works. When you go to flcdatacenter.com, it tells you what the salaries should be. It tells you hourly salary.
Okay.
It tells you hourly salary as well as annual salary.
Mhm.
And by the way, you can divide
Okay.
annual salary by 2080, and that gives you hourly salary. They only have to pay you for the hours you are committed to work.
That they work, yeah.
Yeah, they don't have to pay you full-time salary for a part-time job.
Yeah, but my question is like the USCIS H-1B filing fees and everything is the same as
Oh,
a
I
full-time
don't
job?
I don't know about that. I'm so sorry. I don't do the
Okay.
the fees calculations and all. Our team members do that. You really don't want my opinion on that.
No, I'm saying about from USCIS application fees and everything.
Yeah, that's what I'm saying. I don't do
Applying
that.
fees.
I don't do those calculations.
Oh, okay.
So
Okay.
I don't know what the
All right.
fees are, but the if you look at the form I-129 on USCIS website, it tells you all the details of what the fees are.
Okay. And if I file the concurrent H-1B and I can start working as soon as I receive, I mean, once I file my case, right?
It is my opinion that you can. I cannot say that I have a
Okay.
clear-cut indication anywhere, but I believe even concurrent H1s should be treated the same way as a normal H1
Okay.
transfer is treated. It's just another way of doing
Okay.
H1. So, in my view, yes, you should be able to start upon receipt.
Okay. For starting this process, like, should I do the whole labor process again for this, or
Or you have to do the LCA again. Absolutely. It's
yeah, LCA? Okay.
just like a
And
just like a
will working. Go ahead.
just like a new H1. No difference.
Okay. And will working like concurrent part-time jobs as, concurrent H-1Bs will have any impact on the green card processing?
No, not at all. You're not changing your full-time hours with
No.
your sponsoring employer. I don't see.
No.
Yeah, I don't see any problem. with
Okay.
that. Okay.
All right. Thank you very much. Raj.
Oh, you're welcome. Good luck.
Thank you. Bye.
Bye bye. Okay, I have 4 more questions. So let me get started on the next one. This one is also from New York, area code 518. Go ahead, please.
Hi, Rajiv. Can you hear me?
I can hear you, ma'am. Yes, perfectly.
Okay. My question is, my husband's sister filed I-130 for him back in 2010.
Okay.
But I saw that something on the website. It says that I can file I-485 to have an adjustment of status because I am here and my husband is here since 2005.
Ma'am,
Is it possible?
no. The way it works is you look at a document called Visa Bulletin. Okay. The way it works is
Okay.
you get Visa Bulletin in the middle of every month telling you what the dates are going to be in the following month. So the July visa bulletin tells you what the priority dates movement for next month will be. When you see your priority date, the date his I-130 was filed by his sister, become current in the visa bulletin, in the beginning of that month you can file the case. So let's say on July 15th you looked at the visa bulletin and it said your date is current. On August 1st you can file 485, not before that. And typically, from what I recall, sibling petitions are taking what, 10 years or something like that to get current.
Oh, so there is no way that we can expedite this procedure even if we are here and, for so long.
That is correct.
It doesn't matter.
It does not matter, no.
Okay.
Okay?
Okay. Thank you. I appreciate it.
You're welcome.
Bye-bye.
Bye-bye. Okay, let's, there is a blocked number, so I can't really tell. I can't tell.
Rajiv.
Yeah, go ahead, please.
I'm calling regarding case number 22, TVU.
Oh, TVU. Yeah, go ahead. See, 10, 15 days, and then you went outside, came back, no problem.
Right. Outside, actually, another question. I'm in the F2A category, so the case is becoming current next month.
Okay.
So I'm not in the country right now. I'm outside, and so can I file for the 485 in August?
485 can only be filed if you are physically inside the USA.
Okay.
Okay?
So basically, I have to what happens? I just wait it out, and once I get approved, then I can go inside and file the 485.
What are you waiting for? You're waiting for H1? What are you waiting for?
We've just applied for I-130, and once.
Okay. The way it works is if you are outside USA, your green card will be processed not through 485, but through consular processing. You will get an interview call from the consulate in India, not 485. So you'll come in with a green card. You will not file 485 again. You will land in the United States with a sealed envelope that you'll deliver to CBP at the airport. They'll process you. They'll stamp your passport as having received green card approval. And in a few weeks, you should get your green card in mail.
Okay, sounds good. The current waiting time is about 17 months. I'm probably about at 8 or 9. Do you see any increase, in short enough time?
I cannot predict that. I would like to, but I can't. Okay. Sorry.
Okay, no problem.
All right, take care. Good luck.
And I also have one more question, actually.
Sure. Go ahead.
Sorry?
Go ahead.
My wife is, I spoke to you last time, and my wife has had her green card for about 11 years, and she's not really been in the U.S., so you mentioned that she should go there. So she's there for a while. Is there anything, she's not working, is it necessary for her to be working over there so that she can support my case?
Yes. Either that or she'll have to get some kind of a co-sponsor.
Oh, that's fine. Yes, that should be
and also proof of your own funds, etc., can also be used to support your situation.
Okay, that should be fine. Yes.
Good luck.
Thank you.
You're welcome. Bye-bye. Okay, I have 2 more questions and then we are done. Boy, New York is big today. Again, New York, United States, 646 area code.
Yeah. Hi Raju, this is Anil AP this side.
Yes, sir.
This is regarding the firm case getting void.
Oh yeah, my God! What a strange situation, huh?
I was taken by surprise when I was informed like that, and it happened just end of May. I got informed. So Raju, one question, I just want to give one clarification.
Right.
What I was told is there are multiple. I don't know the exact number, but there are 40 odd people who have got affected from my company itself. And there is another company which is affected. I don't know the names also. But in our case, what they said is, our attorney said is, till they just know that there are cases affected, but our names are not yet disclosed to the agencies. They said eventually it will be, but till now it's not done. Even Friday I verified, so they said till now USCIS or American Council has not reacted at all. So that's why I was asking if I can go and get my stamp done.
Mr. Desai, I would not want you to try that because there are issues here that could become very problematic. I don't want government to take this position against you that in attempting or getting the visa stamping you committed fraud. You knew you were not eligible to get the visa stamping. Okay. So, I mean, I just, it's a very uncomfortable situation. I would not want you to go for visa stamping. I think you can make the suggestion to your lawyers that, a lawyer in Washington, D.C. was saying that maybe you should make a phone call to the U.S. Attorney's Office and see if you can work out a deal with them of some kind in exchange for, providing testimony or even otherwise without disclosing the names of your clients,
Yeah. Okay. So that's what I actually wanted to know because I thought maybe
No, don't take that chance. I wouldn't want you to. No, sir.
Okay, and maybe may I ask one question? Like, there are other people I know like who got affected with similarly, but already got stamped just before they got to know. So even can they face any issue if USCIS decides to take action?
No, if they, of course, all of this can be revoked. Okay, but if somebody unknowingly goes and applies for a visa, gets it, comes back, that is no fraud because there's no intention there.
Okay.
Okay, but if you knowingly go, that becomes a little problematic.
Okay, I got you.
Good luck. Good luck, Mr. Desai.
Okay, thanks, Rajiv.
You're welcome.
I may get back to you after some time.
Sure, no problem. Good luck to you, sir. I wanted to ask Mr. Desai the name of the lawyer, but I don't think that's appropriate. It's just awful. Oh my God, again New York. Area code 646. Go ahead, please. Area code 646, New York. Okay. It looks like we are all done. I still have about a couple of minutes. If you guys have any other questions, press *5. Any other questions? *5. Okay, very good. Folks, thank you very much for being here. And I'll see you again on August 1st, the next call.